Now, next up we're going to have Sam talking about the green wedge zones. For those of you who don't know, the green wedge zones apply to those areas of Melbourne which generally sit outside the urban growth boundary, but before the farming areas. So large parts of the Mornington Peninsula, etc. One of the major issues that's been in the green wedge zone is how you balance the interests of people who live there and who want it to preserve a sort of agricultural feel, and those who want to develop businesses like wineries and restaurants and so on and so forth. And Sam's going to tell you all about the new zones and what they do.
Thanks for that, Nick. I wanted to start by just going back in history a little bit and looking at where the green wedge sort of came from. Now, initially the green wedge zone recognised, protected and conserved green wedge land, and Sir Rupert Hamer called the green wedges Melbourne's lungs. And I think progressively over the years that sort of idea of the green wedges being Melbourne's lungs has slightly changed. Now, in Foster Group and Mornington Peninsula Council, this is a case that I think sort of highlights the changes that have been made, or the thinking that has changed in relation to green wedge land from that of Hamer when he initially spoke of it as being the lungs of Melbourne. And they say in, the tribunal said this in the Foster Group case, that the implementation of green wedge policy requires that a balance be struck between protecting the environment and allowing for appropriate development and use of land that will provide economic and social benefits. It's not the case that green wedge areas be quarantined, and I think that's a really critical point and something that we see now. Not be quarantined and set aside solely for environmental, landscape and/or agricultural purposes. The policy supports development in these areas, provided such development is responsive to its sensitive context and does not compromise the qualities which give green wedge land its significance. So I think, there's a real tension here with the green wedge land. On the one hand, as Nick's already said, you have to recognise that there are people that live in these areas and that these areas do provide some critical resources, and there are examples of quarries and things in green wedge land. But that has to be balanced with the fact that they are, as Hamer said early on, Melbourne's lungs, and we need to recognise that as well. So the key features and the key changes that are being proposed in relation to green wedge land, one, to support agricultural activity. Two, to allow more tourism-related uses. Three, to support population retention to sustain rural communities. Four, to remove unnecessary conditions and unnecessary prohibition of land uses. And five, more permit exemptions are being proposed. So it's in some ways recognising this tension, and that's what the proposed changes aim to do according to the government. There's been some criticism of the proposed changes, and the criticism has come from a number of quarters, including the Environment Protection Office. They say the changes go beyond the minor development flagged in the public announcements that have been made by the government. But the EPA also say that the changes that I've just sort of highlighted, or the features of the proposed changes, undermine the integrity of the zones, and they say it undermines the integrity of the zones by doing two things, and two key things. The first of those is that the 40 hectare minimum lot size and requirement that development be linked to agriculture and other green uses is abandoned. So you've got the lot size gone. The proposal is that the lot sizes will be gone, and that this, in conjunction with requirement that the land be used in conjunction with another use, also gone. So that's some pretty significant proposed changes. If we look at the changes, So no permit now is required in terms of agriculture. So agriculture now in a green wedge zone and as of right use. Now, as many here know, agriculture is defined fairly solidly in clause 74 of the planning provisions, but this will significantly change the way in which green wedge land can be used, and this is an as of right use that currently doesn't exist. Another as of right use that is proposed is in relation to rural industry. So again, agriculture, rural industry. There are some conditions that are proposed in relation to rural industry. So the proposed conditions with rural industry is that it must not have a gross floor area of more than 200 square metres. It must not be within 100 metres of a dwelling in a separate ownership, and it must not be for a purpose shown in the notes to clause 52, excuse me. But essentially what that does is open up this green wedge land from being land that was, again, used in a way that provided for some conservation and so on, and really opening it up to more farming uses and other uses. The bed and breakfast requirement, now currently, as of right, 6 beds, that's going to go up to 10 beds. So again, a slight increase. Allowed with permits under the green wedge zone, now we have schools, medical centres, sawmills, abattoirs, places of assembly. So these currently, as some of you will know, either are difficult issues to get around or they're simply prohibited. So what it's going to do is really open it up. So you're having this sense that the green wedge zone now can be used for things, for living, for schools, for these sort of activities that were otherwise very difficult to get up or not possible to get up in these particular zones. There's further matters that have been allowed with permits but without the old conditions attached. So you can have now function centres, group accommodation, residential buildings and restaurants. So 3 or 4 key areas that have been the subject of a number of decisions in the tribunal, and many would say that the changes that have been made or the changes that are proposing to be made, so allowing function centres, group accommodation, residential buildings without the old conditions that used to attach, and I'll go through some of the old conditions in a minute, but allowing that really does have a look at the cases like the Foster's Group case, like Ginelec, those sort of cases that were difficult and were difficult because the applicants often had to find some sort of link between what they were using the land for, like if it was they were using it to grow wine. You had cases where there were a couple of grapes on the land, but then they wanted to put in a massive function centre and restaurants and hotels, and they were saying, well, because we've got a couple of pot plants with tomatoes in it or something to that effect, the land use that we're after in effect is the function centre. So I think in some ways these changes address those issues that the tribunal has looked at and are probably a little more honest in some ways. So rather than finding links that otherwise weren't there in the past, but lawyers coming up with clever arguments to say that this use of the land is in conjunction with that use of the land and having these clever links that were always made, I think now it's probably a bit more honest in that what the proposals are saying is that you can have a function centre and you don't have to worry about any of those links. You can have the restaurant, you don't have to worry about those links in the green wedge zone. So currently for function centres in green wedge zones, it must be used in conjunction with agriculture or outdoor recreation facility, rural industry or a winery. There's a limit on the number of patrons that can be present. The number of patrons can't exceed 150 in most cases, not in all cases, but in most cases. There's also a prohibition on the lot size, so the size of the area that we're talking about, there's a prohibition on that as well. Now all of that's gone. So function centre, those conditions that attach to function centres gone. Similarly with, pardon me, group accommodation, residential building, restaurants and so on. So to sum up, I think the outcome of these proposed changes is to move away from the position that Sir Rupert Hamer initially took in relation to green wedge zones, and that is that, you know, green wedge zones were something to be protected. There's a move away from that, and I think there's also probably, and this is, you know, this is debatable, and you know, everyone will have a view on this, but there is a move to a simpler, probably version of the scheme in relation to what's allowed. So I think the sort of Ginelec and those cases down on the Mornington Peninsula where you did have, you know, people running off to the tribunal to argue about whether or not a use was in conjunction with another use, I think that will in large part go away. But I've written down a quote. I was speaking to a fairly senior, well, I was speaking to a silk and a senior silk who practices in this area, and we were talking about these changes, and I said, what do you think the impact of the changes will be ultimately? What is going to occur with these changes ultimately? And what he said is, I think if the proposed changes are adopted, it will lead to more certainty, which in turn will quickly lead to more uncertainty, which is a good thing for all of us. So, and I think that's probably the case with the changes to the green wedge zone. Thanks.
And don't ask him who said that. It's all off the record. Now, the last speaker is Tom Vasilopoulos. Tom came to the bar in 2011, read with Adrian Finanzio, came from the Moonee Valley City Council where he was the in-house solicitor and apparently did everything. He was also the municipal building surveyor, manager, statutory planning and enforcement and manager of property services. So Moonee Valley suffering, we've got the benefit of Tom.
Reform industrial zones. The existing controls specific to industrial zones include the Industrial 1 zone, the Industrial 2 zone and the Industrial 3 zone. Unlike the proposed new residential zones and the new commercial zones, there are no new industrial zones proposed. And this was touched on by Andrew Woods earlier on. Instead, it is proposed to replace the existing industrial zones with the improved industrial zones, which aim to support business, investment and industry by allowing for a better mix of industry and office and providing greater incentive for business. The two main changes proposed to the industrial zones are as follows. The first one is to remove the default floor space area restriction for an office in the Industrial 1 zone, Industrial 2 zone and Industrial 3 zone. More precisely, under the current planning scheme, industrial zones have a floor space limit for office use of 500 square metres, and that is under Section 2, the permit required use, specific to each relevant industrial zone. Now, the reasons for this change was that it was considered that a restrictive cap of 500 square metres was based on a traditional industrial building, which is considered no longer relevant in the current market and not a viable option. So that is a significant change, because what it basically means is that you'll be able to construct office type buildings or office developments in all industrial zones, providing the relevant planning permit is obtained. There's no limitation on the floor area, so you can ultimately have even multi-storey type offices in industrial zones. The actual proposal to remove the cap of 500 square metres for office use is basically to allow the ability to develop modern and more innovative industrial buildings which complement the current trends in the market. However, councils will still retain the ability to schedule in a floor space requirement where it can be justified. So council still have that option where they could place a limitation, depending on their reasons, to cap the actual floor area. The second major change is to allow a small-scale supermarket of up to 2,000 square metres of leasable floor area in the industrial 3 zone, and that's without the need of a planning permit. So an as-of-right proposal to allow a supermarket to be constructed in industrial 3 zones. Further, to allow supporting shops which adjoin or are on the same land as a supermarket in the industrial 3 zone without the need of a planning permit, so another as-of-right proposal, providing the combined leasable floor area for all shops do not exceed 500 square metres. So this is a significant change in the industrial 3 zones because it ultimately allows mini shopping centres with supermarkets in industrial areas as of right, without requiring any permit. The changes proposed to be incorporated in Section 1, permit not required use of the relevant clauses specific to the industrial 3 zone. Now, the reason for this change is to facilitate commercial opportunities and enhance competition in the sector, and to allow, I suppose, further shopping strip type developments in the industrial 3 zones. Other minor changes, and these are more administrative in nature, include the deletion of the business 5 zone reference in the industrial 1 zone under clause 33.01 and 33.02 and 33.03 respectively, relating to each industrial zone. And business 5 zone was mainly referenced there as a requirement in some specific uses which required a buffer distance from a proposal in an industrial zone. So the main reasons for these changes is to, I suppose, correspond with the proposed changes of the removal of the office area cap, and also to correspond with the reformed zones, and that is business 5 zone will become a commercial 1 zone. Now, the issues that arise with these reformed industrial zones, I've just put some dot points here. Whether the complete removal of the floor space limits will create an overdevelopment of office type uses in industrial areas. So I suppose it's an issue that's being considered at the moment. Whether as of right retail development in industrial 3 zone areas will compromise the balance of rural and regional townships, thus undermining the commercial viability of the core of these nearby centres and townships. Whether small neighbourhood centres that rely on supermarket presence to sustain a high level of business activity will be diminished. So that's another issue that's, I suppose, being created with these proposals. And whether there will be a weakening of activity centre policy and the loss of available industrial land. So there's some of the issues currently, I suppose, being considered by the government and the effects that these proposals may have. Now, the next slide just shows the actual changes to the industrial 1 zone, industrial 2 and 3 zone. Again, they're on the website, and you can have a look at that in your own time, but basically it's a summary of what I've just indicated. I'll end by basically saying that if you didn't do well this week in the Melbourne Cup, or you are unlucky with Oslotto, my suggestion to you is if you want to back a winner, go purchase some land in the industrial 3 zone, because that's the big winner in this reform zone. That's basically it. Thanks.
Thank you very much. So what does that all mean? Okay, well, for those of you, even if you're not, even if you don't have anything to do with planning as a area of practice, but if you live in this community, it seems to me that whoever drafted these is of the view that there are too many houses in Victoria and not enough supermarkets. So what we've got is, on one hand, a potentially extraordinarily restrictive regime for residential development, and indeed when they were released, the Minister proudly touted the neighbourhood residential zone as the strongest residential protection zone ever offered in the Victorian planning system. So strong that you could limit development to no more than 2 houses, no more than 1 story theoretically. with a lot size, a minimum subdivision size of 1,000 or 2,000 square metres. Now, if, as we suspect will be the temptation of a lot of inner city councils, your Baysides, your Boorandaras, your Stoningtons, that type of restrictive zone is implemented in a widespread manner across most areas, established residential areas. What you're going to find is a real risk that we will not be able to accommodate the projected future population growth for this city. And what that's going to mean, of course, is we get more urban sprawl. In terms of the retail, the opening up of areas previously where shops were prohibited, or at least prohibited other than in a very small area, is going to mean, as Tom indicated and as indicated, that we've got a huge areas of land now available where shopping centres, small supermarkets and satellite shops can establish as of right. That means without having to go through the planning system. And as has been indicated, we've got a 40% increase in the land, theoretically, which is where shop is available as of right. We've got somewhere in the region of a 5 times increase in land in which you could have bulky good retail, those big box retailers, the Good Guys, the large format sort of ones that you see usually in a strip driving down towards Dandenong, and a 3.7 times increase in land where you can have supermarkets as of right. Now, on one hand, yes, there's no doubt people will start building more supermarkets, more retail facilities, but what is that going to do to existing centres? What is that going to do to investment that people have made in existing, not just the big standalone Chadstones and your Westfields and your Northlands and Southlands, but the strip shopping centres where land costs are very high, development is very restricted because of, say, heritage overlays, and how are they going to be able to compete with someone who can go out and build a 3,000 square metre, or maybe not 3,000 square metre, but a small supermarket on cheap industrial 2 land? And all that means, what it might mean, is that we're going to have a whole lot of isolated activity centres or retail centres. People are going to travel more, people are going to rely more on the car, and all of those centres are going to be competing against each other to the extent that none of them are viable. Now that's the worst case scenario, but clearly those sort of potentials are opened up when you remove planning controls and when you say, okay, it's just basically wherever you want to put a shop is okay. Now, the time's now 8:30. We're more than happy to answer any questions that anyone's got or to respond to any areas of discussion.
I suppose my first question is how much, to what extent do you think these proposed changes will remain intact? To what extent do you think there will be changes to?
I don't think there'll be any fundamental changes. As I said, there is a process now by which there's the independent committee which is considering submissions, but it seems to me that they've been pretty much developed and presented as a fait accompli. There might be fiddling around the edges, but I wouldn't expect any wholesale changes. That's always dependent upon the extent to which the lobby groups get involved, and there are some very influential and powerful people who own shopping centres who are no doubt banging on the door of the Premier or the Minister at the moment saying, excuse me, you're going to cost me a lot of money. Anyone else? Yep.
Is there any
Just,
sign...
if you wouldn't mind in the microphone. And you can sing as well.
I'm only a dabbler. Is there any sign at present of any rush to get things done before this comes in, or of holding back, waiting until it comes in, and if so, in what areas?
Tom's buying a lot of land at the moment.
Yeah. I don't think there's any rush to get things done because in terms of commercial development, firstly, if you've already got an existing development, you want to be holding and seeing, you don't want to be putting any more money into it at the moment. Secondly, if you've got your industrial 3s and you're just sitting and waiting for the floodgates to open. In terms of residential development, it's possible that you might see people trying to, if they've got a big lot, say in an established area in Bayside, they might put in an application just to try and preserve their rights. But I haven't seen a lot of it, but it's possible that it may happen in the future.
In terms of residential, the zones won't be translated directly, so anything that's residential 2 at the moment won't automatically become the new residential growth zone. What's going to happen is that councils are going to have to go through and effectively audit their land and decide which category they want it to fall into. So it could be quite a long process. And there's a question about whether or not councils will have the resources to do this. It's quite a big undertaking to go through and rezone all your land. And as Nick referred to, it's probably there would be a temptation to apply those restrictive zones to broader areas than are currently residential 3. So it could take some time for the residential zones to actually come into effect.
Yeah, the other area of uncertainty, obviously, with the residential zones is, as Tiphanie indicated, you've got the zone controls and then you've got these schedules, and the schedules can be individually tailored for specific areas, specific councils. So until they produce the schedule that says, for example, you know, in this area the lot size is going to be X square metres, it's going to be, you know, a 10 metre height limit rather than the default height limit and those sort of things, you won't know really how even the new zones work. Yeah. So, you know, what they've done is to provide a framework where you can craft very restrictive or not very restrictive controls over residential land, and the devil is going to be in how they're implemented. And that may take a while, or it might just be, let's just get it done. And the easiest thing, of course, is to put the most restrictive zone everywhere except around very small areas. And I suspect that's what they're going to start doing, and will be dependent upon DPCD to be the gatekeeper and to say, no, hang on, we need at least 2 lots within the city of Bayside that you can build higher than 2 stories on, please.
In addition, if I might add, in relation to submissions that are made on the zones, it's very difficult to make submissions where most of the detail that will determine how these things are used is going to be in schedules and isn't determined yet. So the question about whether or not there will be any public consultation when councils are looking at which zones to apply where and what to put in the schedules is quite a big one, and there's just no indication of what that process will be.
If you've been sitting on a big area of residential land hoping for the right time to put forward a development proposal, I'd say it's rapidly approaching.
So a follow-up question. At present, would you be saying to people that they ought to be seeking to get permits and stick them in the drawer against what might happen?
Well, it depends on where you are. Certainly, if, as I say, if you own, say, a big lot of land somewhere in an established inner city suburb that has a fair potential to be subject to one of either the slow-go or the no-go zones, yes, I'd get in there now, and I'd get at least a proposal which gives you something. You can have your permit even if you don't act upon it immediately, or if you don't ever act upon it. The fact that you have a development approval for something is a factor that can be taken into account in the future. So, yeah. The permit stays live. The permit stays live.
2 years?
Well, you know, the standard time is 2 years to start and 4 years to finish, but you can extend it, and some permits are longer. But the permit, the right created by the permit persists even though you can't change the zone. Yeah. Well, again, we don't know if there'll be a transition. There's unlikely to be a transition. It's likely just to be like the new format zones. Day 1 it was, and day 2 it's not. So then that's the way it's likely to work. Anything else? All right, well, can we thank you very much for coming? I know it's a struggle to drag yourself out of bed and to sit here and listen to a lot of technical talk about things, but we do thank you for your attendance. And if there's any questions that you have over the coming weeks, months, years, feel free to give anyone here at the table a call, so you can, or if you see us in the street, buttonhole us. Thanks very much.